He's here with us. Our friend Glenn Kirschner, former 30-year federal prosecutor, served in the U.S. Army and JAG Corps, a legal analyst for NBC and MSNBC. He's got a podcast, a YouTube channel, Justice Matters with Glenn Kirschner, and more. And I was at his dinner Saturday night in D.C., and it was a lot of fun. Glenn, I talked about it on the show. I praised the people, such great, nice people that I met there. Really. And so many recognized me, which was kind of remarkable because if they watch MS all the time, and I had just been on MS that morning, and they're like, "I know you," and it was so. What a nice group of people.
No, I actually showed him a picture of you before you got there, just to make sure that I didn't want you to feel left out.
Oh, thank you. It's funny, but I saw Frank Figliuzzi. I went up to Frank and go, "Are you working security at the party? Is that why you're here?"
Oh, that's a great line.
I said to him, and so we kept telling Pete, like, "You're wanted in the kitchen." It was like running jokes. Where it was nice to meet Harry Dunn, who's him and Hodges, also a bigger guy than you think. Daniel Hodges is a big, stocky
Hodges,
guy.
And I'll tell you, and Mike Fanone, who comes and joins us every year, just had a health problem in the family, so he couldn't make it. But, I love to have those American heroes come every year to our Team Justice gathering. And I have to tell you, Daniel Hodges really snuck up on me because when he took to the podium, and remember, I hate to even talk about it, but he was the one whose head was getting crushed in those doors on January 6th. The first words out of his mouth were, "I'm Daniel Hodges, and I'm a crisis actor." I mean, that and what these men went through, they deserve all the love and support that we can give them.
It was great. And Harry Dunn was such a nice guy and a funny guy. And he went on stage and I gave him my card. And when his book comes out, I know he'll reach out then and we'll have him on. And when Frank was on Monday, we talked about your cruise. We'll talk about it more when we get there. Me and Pete are working on a cruise on the Hackensack River. It's going to be beautiful. You go to Secaucus, Bayonne, all the stuff, maybe Paramus if you're lucky.
Nice.
Shopping on Sundays. Shopping on Sunday.
Make sure you get your shots, get your vaccines before that one.
Don't mock my state. You're a Jersey guy originally. That's what I learned. Is that right?
I'm a Jersey guy. You bet I am. Yeah.
I scream Jersey. You don't. You seem more like Virginia, something Maryland. But all right,
don't insult me now. Exit 98, ride or die, Garden State Parkway.
Oh, wow. Well, I'm 164, way up at the top, right at the really near the end. So there's so much law stuff going on. A short time ago, while this isn't criminal, involves Rudy Giuliani. So, and it could be irrelevant to the criminal trials, perhaps. But the federal judge, Beryl Howell, just entered default judgment against him. He was so obstinate and intentionally blocking discovery, where the judge said, "I'm entering default against you," sanctioned him, making him pay $89,000 for plaintiff's attorney's fees. And to remind people, this is the lawsuit by Ruby Freeman and Shay Moss for defamation, because he lied saying they were passing around the USB port like it was vials of crack, and saying they were lying about the election and they were involved in fraud. So what's your reaction to this? And how much did he have to do, Giuliani, to get a judge to actually go like, "I'm entering default against you"?
Yeah, he really just sort of figuratively thumbed his nose at Judge Beryl Howell at every turn. I think he was trying to keep from having to give over stuff in discovery that would have been damaging to him, not just in the defamation suit, but in the criminal case, soon to be criminal cases, plural, against him. And so he was willing to take a financial hit. And, when they put this in front of a jury on the question of damages, compensatory and punitive, boy, he's going to get banged out for multiple $1-million judgment. The other thing I love about this whole litigation, first of all, I love that Shay Moss and Ruby Freeman are exacting revenge, not that they're looking for revenge, but what he and Donald Trump did to those two Georgia poll workers, in their words, when they testified before the January 6th House Select Committee, they ruined our lives. And they almost did it for sport. So I can't wait for Rudy to have to pay through the nose to make them whole as best they can be made whole. But the other thing I love about this litigation is Rudy filed a pleading in court and said, "I lied about them and I defamed them." And then he tried to say, "But you can't use that against me in a criminal prosecution." Rudy, I don't know if you were sober or you were drunk when you decided to make those admissions, but they can be used against you in the criminal case. And that's part of the charges down in Georgia. So he's done down in Georgia as well.
It's remarkable. And, we haven't spoken on the show since the Georgia charges have come out. I find it really interesting that they keep yelling, on the right, the GOP and MAGA, that Trump is innocent, but they don't say the 18 other people are innocent, just Trump's innocent. So the other 18 people, they'll throw him on the bus. And no one's out there going, Giuliani's innocent. No one's saying Sidney Powell is innocent, or Cheeseborough or Eastman. You don't have any Republican, but you have Republican members of Congress going, Donald Trump, this election interference. So what's your reaction, and how significant was this with 19 defendants, sweeping RICO charge and everything?
Huge, absolutely huge. And not to make it a criminal law class, Dean, but what you just said was so important. They're not even defending all of the other co-conspirators who were charged with committing crimes in concert, right, with Donald Trump. And the law of the conspiracy law is that if one member of a conspiracy is guilty of something and all of the members were part of the conspiracy at the time, they're all guilty whether they did it or not. So your point is an excellent one. Even if they're defending Trump, if you don't get all of the other co-conspirators off, Trump gets convicted anyway. These people are not strategic thinkers. But here's the thing. Jack Smith's prosecution in D.C. for January 6th is built for speed and alacrity, to the extent anything in the criminal justice system is ever done with alacrity. And Fani Willis's prosecution in Georgia is built to be a comprehensive holding accountable every last person who committed a crime in violation of Georgia state laws. Two very different prosecutions, two very different approaches. But boy, I think we're going to see justice achieved at the end of the day in both of those cases.
It's just a matter of timing for them. I mean, the Trump lawyers wanted in the January 6th case, April 2026 for a trial date, which was laughable. And what I found really interesting is, Jack Smith wanted January. Judge Chutkan, who I know you know because you used to try cases against her when she was in the Federal Public Defender's Office, she kept asking Trump's lawyer, John Lauro, well, what date works for you? And he wouldn't give a date because he didn't want to say, because then, even though she wasn't going to give him that date, he wanted to be like, no. It's like if a police officer pulls you over and goes, you know how fast you were going? Never say a number over the speed limit because it can be used against you. So there's Lauro doing what I've done with the traffic stop. I don't know, officer, how fast was I going? Because if they had the radar, he didn't have the radar. I knew this because I used to try cases in municipal court. But so what's your take on the fact that Laura would not give a date, and then she set March 4th, 2024 as a trial date?
Yeah, Lauro did not do himself any favors in the way he comported himself during that status hearing. Let me just go back to one thing. Judge Chutkan, Tanya Chutkan, was actually a public defender in local court in D.C., not even a federal public defender in local court. Think about Brooklyn, Bronx, Manhattan, Chicago, Detroit. This is the rough and tumble. This is where the justice in D.C. is done. I was a prosecutor in that court trying murder cases against Tanya Chutkan. I just didn't want people to think that she was only, I use that word advisedly, a federal public defender, because frankly, the pace there is much easier, much more genteel. Prosecuting in federal court, which I did, is very different from prosecuting in a local city court, which both Tanya Chutkan and I did. She was defense. I was a prosecutor. I tried murder cases against her. I tried murder cases against her husband, who's a recently retired judge now in D.C. These are long-term, dedicated public servants in the best sense of that term, because to the extent, I know I'm preaching to the choir, but let me preach for just a second, Dean. To the extent people think, well, the prosecutors are the public servants and the police officers are the public servants, true, but public defenders are the public servants because they're zealously representing indigent clients. They're honoring their Sixth Amendment right to counsel. And as we both know, Dean, the public defenders are also guarding against government overreach and abuse, right? So they're doing double duty. Those are public servants. So now what did I think about John Lauro? I was in the courtroom.
You were in the courtroom, so I wanted to establish it for people.
In the courtroom proper, yeah. So he started loud, and he got louder during the course of the hearing. Judge Chutkan twice told him, and I quote, take the temperature down. She pushed him and pushed him and pushed him on an alternate proposal, a reasonable proposal for a trial date. He said, nope, it's got to be 2.5 to 3 years in the future. April 2026. She said, and I quote, that's not happening. Give me a reasonable alternate proposal. And he wouldn't. I mean, he really did cut off his nose to spite his face. He could have said, okay, How about December 2025? How about, you understand you need to take your cues from the judge.
Sure.
So at the end of it, she said, fine, it's going to be March 4th, 2024. I'll see you for jury selection. And then he threw a tantrum. Here's what he did. She said, Mr. Laura, will you please propose the next status hearing date that works for your calendar? He said, I don't see the reason. I don't see why we need a status hearing date. Dean, you don't behave that way
Is he
in
being
court. You
disrespectful
don't
to the
throw a
judge?
tantrum.
Right. Is it a sense of
Yeah,
just being
you
disrespectful?
don't throw a tantrum. You don't throw a tantrum when you don't get your way. You soldier on, you lawyer on. And then he stood up and he said, we're going to be ineffective because, which you can't announce you're going to be ineffective in the future. That's not the way ineffective assistance of counsel works. But he did not distinguish himself on any front.
Do you think there was a bigger strategy? I mean, I know people say you're playing for an audience of one, but the TV cameras are not on for Trump to watch him do this. And is he trying to antagonize the judge? I'm trying to get at, do you get there's a sense of strategy? Because Norm Eisen used to be practicing the same firm as John Laura. Norm Eisen told me in an interview a few weeks ago that Laura's a good lawyer, and so I'm like, so he's not like a dopey guy. So is there a strategy? Was he hoping to get her angry? Then he can go, I have to get a recusal, or was it all for show for Trump, even though Trump's not actually there?
It was for show, in my opinion, for Trump and for Trump's base. He was throwing red meat to the base the whole time, yelling about literally, this is a political prosecution. This is a grave injustice. This is and he called the prosecution every name in the book. He may be a good lawyer, but I'm quite sure his client said, you don't give her an alternative trial date. You don't back down one day, because that's not what I want you to do. And as you know, Dean, when you represent clients, yes, they have a say, but they don't get to make every tactical call. You have to do some smart lawyering, even if it's not precisely what the client is demanding.
I'm chatting with Glenn Kirschner. At the end of the day, you wonder if Laura ends up like so many of the others, from Evan Corcoran being forced to testify against Donald Trump, to actually having to get his own lawyer, to being a co-defendant in a trial. And I'm not wishing that on Laura. I mean, I will say, like, in his brief, in writing, he put, this is a political prosecution. I'm like, that seems like you're going over the line. I know you're supposed to zealous defense of your client, but when you put as a matter of fact in a brief, like he did when he wanted the April 2026 trial date, I'm like, how come this is not beyond the pale of what's acceptable from a lawyer before a court?
It is, but he is doing what his client demands that he do. And Dean, why do you think Donald Trump runs through so many lawyers? I mean, I think people might come to the endeavor with the best intentions, thinking, I'm going to be the one to tame this, big orange beast. And nobody can. And they fall one after another. They get disbarred or suspended one after another. I don't understand why lawyers keep stepping up and being willing to represent him. Now, none of the big firms are willing to step up and represent him, and that's kind of why he's stuck with who he's got.
It's interesting. I mean, because it's almost laughable, because if he tries to do like the advice of counsel defense in the Georgia case, he'll be like, the lawyers told me, look, they're standing right next to me. Just ask him yourself, Judge, because they're all defendants with him. I mean, it's like,
and that's
it's
a really great point, because advice of counsel is a legitimate defense. And here's an easy example. Your tax lawyer says you can take that deduction, and then the IRS comes after you because you couldn't take that deduction. What do? You say, advice of counsel, my tax lawyer, and that can work. That's a legitimate defense. But when your counsel, when your lawyers are your co-defendants because you were in a criminal conspiracy with them, you know what? There is no advice of co-conspirator defense.
And you can't go shop. Like, if you went to 10 tax lawyers, for an analogy here, and 9 of them said that's illegal, you can't do it, and 1 said it's legal, there's no more good faith. So you lose the advice of counsel defense, because good faith is baked into it. There has to be good faith. It can't be. And what Trump did was shopped around the legitimate lawyers, from Cipollone to Bill Barr and others, like, no. There's no fraud. You can't do this. You can't pressure Mike Pence. And he finds these radicals who don't believe in democracy, essentially, to go like, yeah, you could do whatever you want, Donald. You're the man.
Mm-hmm.
And so they get charged. I'm chatting with Glenn Kirschner. So, Glenn, we know that Trump's goal is to delay the January 6th trial, is his most potentially lethal for a trial date happening, a real trial happening. And by the way, can you tell people, barring anything out of the normal, when a federal judge sets a trial date like this one with Judge Chutkan, March 4th, 2024, how realistic is that?
It is entirely realistic. When federal judges set trial dates, they expect those trial dates to hold. Do they always hold? Not always. Sometimes they slip. Sometimes, you do have a legal issue pop up that takes some more time to litigate and resolve before you can begin jury selection. Dean, sometimes attorneys get sick. Sometimes there are family emergencies. So, today, for example, the Proud Boys sentencing was supposed to happen. Judge Kelly, got sick. So it happens. Sometimes they slip. And I think maybe Judge Chutkan built in a little bit of cushion such that if it slips from March to April, okay, that's fine. But no, knowing Judge Chutkan the way I do from back in the day, she's no nonsense. She's all about business. She expects her orders to be followed. And I think she means what she says when she says we're going to start jury selection on March 4th.
We know that Donald Trump's lawyers are going to try to delay this. Everyone understands that. So they'll try to appeal interlocutory order, like orders within the pretrial part. Are there any that we should watch out for that have a more successful, potentially successful chance to actually stop the trial? I mean, he might even appeal the trial date, which is a loser, but say they appeal, they want to change a venue and they lose that. Are there any that can actually stop us going forward to the March 4th trial date?
The short answer is no.
Okay.
People get used to, that's a bit of an overstatement. The judge could go completely sort of beyond the bounds of a lawful order, for example, but that's not going to happen. People are used to Donald Trump manipulating civil cases, civil litigation, where you can do these interlocutory appeals, a fancy word for an appeal mid-trial, right? You can piecemeal your appeals on all sorts of rulings by the judge. And Donald Trump is the best at manipulating those kind of opportunities and running out the clock. That's not the way a criminal trial works. You get to appeal after you've been convicted and sentenced. That's when you get to appeal. So, no, and the other thing is you want to file interlocutory appeals. You know what the appellate court is going to say? That's fine. The trial will proceed while your appeal is pending. So I'm not worried about Donald Trump being able to successfully put a temporary stop to his criminal trial.
And I'm so glad I asked you that as someone who's tried cases in this very jurisdiction in DC. That was your stomping ground. Glenn Kirschner was known there. So Glenn, you've had a lot of murder cases you've done, and I'm sure organized crime was involved. Is the threat to jurors and witnesses in Donald Trump, does that eclipse the concerns you had in cases in the past that you actually handled?
So I tried a series of RICO cases, Dean, in that very courthouse where it was a criminal organization that had killed 30 people over the course of about 10 years. They killed their competitors. They killed witnesses. They killed members of their own crew when they tried to leave the crew, because nobody gets out alive, because then you run the risk of that person flipping and snitching. So we had an anonymous jury because of the danger to the jurors. We were in the secure courtroom, which they have since disbanded, which the well of the court was separated by bulletproof glass from the audience. We had our defendants wearing 100,000-volt stun belts under their suits because Judge Lamberth had ordered that for security reasons. And guess what? They still got to some of the jurors, and some of the jurors had to be dismissed mid-trial. I have tried cases involving the sort of most rigorous security measures ever in the District of Columbia. I have an even graver concern for Donald Trump because his reach is so broad, his followers are so rabid at times and so detached from reality. I'm sorry, this is a cult. And so, yes, I am concerned that the judges have not yet stepped up to address the danger, the ongoing danger, the demonstrated danger of Donald Trump to witnesses, to jurors, to prosecutors, to judges, and to their families. I hope at some point the judges realize that Donald Trump is a danger to the community and he should be detained pending trial, because that will begin to neutralize the threat, in part because you'll take his megaphone away. I think we're going to be having that conversation in the months to come.
And we should. Last night on the show, I had a doctor on, Dr. Bandy Lee, who's a forensic psychiatrist, who wrote a book a few years ago. She was the editor of all these mental health professionals talking about Donald Trump. And she said, and it was almost counterintuitive, she said, if Donald Trump is put in a prison, it lowers the temperature, doesn't raise it. Because I said, are you more concerned that he's put in a prison or out? She said, no. When he's in and it's not in the media and can't use social media, she goes, from all her work with gangs and gang leaders, she goes, it brings the temperature down. It actually makes things safer. The longer he's out there, the more of a threat he is. And I was like, wow. And I made her repeat. I go, hang on, I used to. And she said, yeah. So to me, that is such a guiding principle that I hope a judge, it's not like they're going to put him in and they're going to attack the prison. It kind of brings things down. The difference is he's going to have his allies in the media screaming in the beginning, but maybe they calm down. I'm not sure. It's hard to say.
Yeah, I read Dr. Lee's book, The Dangerous Case of Donald Trump, and I couldn't agree with her more. And all of the other experts, there were dozens of them who weighed in on the danger posed by Donald Trump. But here's the thing. If you take the cult leader away, the cult members are not going to organize and rise up. They're going to be a little bit rudderless. And you know what they're going to do, Dean? They're going to look for another cult member. And there ain't no other cult member like Donald Trump. There are a lot of little wannabes out there, but they're not going to galvanize around anybody else. So let's do what the law requires, which is pretrial detention for somebody if there's clear and convincing evidence that they're a danger to the community, and Donald Trump is.
I agree. I'm chatting with Glenn Kirschner. Last two things, both about Fulton County. We have certain defendants, Cindy Powell, Kenneth Cheeseborough, and a few others, want this October trial date. And Fonnie Willis, the DA, wants everything together, not severed, or at least make the motions to sever. She wants some clarity, she's asking. From a point of view as a prosecutor, are there challenges? Are there benefits to having this piecemeal? If you had this in October and then you tried Trump next year, what's your take?
Yeah. So in the RICO cases that I was just referring, we indicted more than 24. There's some strong parallels, at least based on the numbers, to what's going on in Georgia. Indicted more than 24, all but 13 pleaded guilty, some with cooperation, some without. We had to go to trial against 13 RICO defendants. In DC, in federal court, the U.S. Marshals sets a hard and fast rule. We can provide courtroom security for no more than 6 defendants at a time. So the judges don't buck that. And so we broke it out into 3 batches. We did 6 defendants in trial 1, 6 defendants in trial 2. Then I had to do a 1 co-defendant RICO trial against 1 defendant, which took me 3 months. But we had to do it in a wave of 3 trials. So I'm telling you, I hear Fonnie Willis over and over again say, I'm ready to try all 19 together. I don't know if she's going to rent out a stadium. I'm not sure. But what she has proven time and again, she doesn't even own a pair of kid gloves. She's like, let's go. We're ready. So the severance issue is interesting because 2 of the defendants have demanded a speedy trial, which means they have to go to trial by the end of October. Kenneth Cheeseborough has already been given an October 23rd trial date. Sidney Powell will probably be batched in with Cheeseborough. What about all the others? Well, when you go to trial against only some co-defendants and the others will go in a second or third trial, there are pros and cons. But what the defendants will do, I promise you, because this is what they did in the cases I tried, they will point to the empty chair. Kenneth Cheeseborough will say, whoa. Yes, I may have sketched out a little something about alternate electors, but the dean of a law school who's a constitutional scholar, John Eastman, said it was on sound legal footing. And that empty chair right there in which John Eastman should be sitting, that's the bad guy. Convict him in the next trial. Don't convict me. Sidney Powell will say, whoa. Rudy Giuliani assured me he had all the evidence of fraud in hand. You see that empty chair where Rudy should be sitting? That's the bad guy. Convict him in the next trial, not me. Now, Dean, I'm not saying these are successful defenses. I'm not even saying they're fact-based defenses. Often defenses aren't. They're all about argument and reasonable doubt. But the empty chair defense can resonate with jurors when you have to start splitting out, severing out certain co-defendants.
It's really interesting. Well, Glenn, we're out of time. It's always great. I always have more questions than we can get through. But Glenn, follow Justice Matters. He's got a whole team, Justice Warriors. There's some great people out there. His YouTube channel, check out his articles. Everything he does is fabulous. My friend Glenn, great seeing you. Talk to you soon.
Thank you, Dean.
Have a great day.